Welcome back to Fiegel Files, where we break down the law, life, and strength. Today we're diving into the real-world impact of the courtroom. Most people only see the legal system from one side, standing at a counsel table or as a party, serving on a jury or watching their case unfold in a few short moments before a ruling's made. What they don't often see is the perspective from the bench. These episodes about understanding how the court works, how decisions are made, and what judges wish the public and lawyers better understood about the process. This is an educational conversation, not legal advice. If you've ever wondered what really matters in the courtroom, this is a conversation you don't want to miss. My guest today is Judge Mary Lou Alvarez of the 45th Judicial District Court. She's dedicated her career to public service and the administration of justice. She's currently in her second term on the bench and running for her third term. Before taking the bench, she built her legal career with a deep understanding of advocacy, professionalism, and the responsibility as a lawyer of 15 years, not just to her clients, but to the legal system as a whole. A majority of her practice was spent working with the Texas Rio Grande Legal Aid, representing victims of domestic violence during divorce, custody, and protective order litigation. Her formal education's not only in the legal field, but also in engineering as a community educator, receiving her Bachelor of Science in Industrial Engineering from Stanford University. That's amazing. 2 years later, she completed her Juris Doctorate, 2 years, not three, from Seton Hall University School of Law.
No, it was 3 years.
It was 3 years.
But I went to law school 2 years after I finished. So I didn't go straight through.
I got you. I want all this in. You're not editing any of it. I want it all in. Ashley wrote that, guys. That's what it is. Do your research. Yep. As a judge, she brings a unique perspective shaped by years of experience evaluating evidence, weighing credibility, and making decisions that have real and lasting impacts on the people who come before the court. Her motto is justice without exception. As a judge, she's provided training to improve outcomes in civil court that will meet the needs of our most vulnerable children. Today, we're going to talk about the courtroom from the judge's perspective, what judges look for, common misconceptions about the legal process, and the leadership and responsibility that come with serving on the bench. Judge Alvarez, thank you so much for joining me.
Thanks for having me.
Mm-hmm. Well, welcome. She wants me to say legal heavyweights because she has this great graphic that goes with it. So I'm going to say this is our legal heavyweight.
Ooh, I love it.
Right?
I'll be a heavyweight.
Mm-hmm. Where are you from?
I'm from San Antonio.
You are?
So I was born in Karnes City. So
Wow.
Folks who are familiar with Karnes County. So what is it, an hour and a half?
East, north, southeast of here?
Southeast.
There's 12 other people there, I think. So yeah.
They're all related to me.
Apparently.
No.
Wow.
So my dad grew up in Karnes City. My mom grew up in Kennedy, which is the neighboring town.
Yeah.
And they met at B County College when it was B County College, but they met in Beeville.
How much further is Beeville? It's a little more east, right?
It's a little more east, I think, closer to Corpus.
Yeah.
Yes.
Okay. And so you were born there. How long did you live there?
I didn't live there long because we were all over South and East Texas until 1980. And so I've grown up here. Mm-hmm. I came here before I turned 5, and all my education, grade school, high school, middle school, was here in San Antonio. So this is home.
Where'd you go to high school?
In Carned Ward.
Oh, okay. Wow.
So yeah. I did Catholic school from 6th grade to 12th grade. I did St. Paul's, which unfortunately is now closed, but I did St. Paul's for middle school, and then I went to Incarnate Word. But my school district, if I would have stayed in public school, I would have gone to Pease Middle School. Yeah. And I would have gone to John Jay High School.
My son's a Jay.
Is he?
Yeah, we live way west in Collison Ranch, but they have a magnet now. They have a whole new building for that, for like STEM. So for magnet, so he's a sophomore there.
Yeah, it's a beautiful campus.
It really is.
I go up and down, and it's a beautiful campus.
Yeah. Well, that's awesome. So how do you go from there to Stanford?
I did not know Stanford even existed when I was in high school.
From Karnes City, yeah.
Yeah, I had no idea. But the school secretary, because I was in student council in high school, and so the school secretary had a daughter who had gotten accepted and was going to Stanford. And so when I'd come in for the morning announcements, she told me, you really should look at this school. You should think about this school. I was like, I have no idea what it is about.
And so you don't even know it existed. You don't even know the prestige that goes with it.
I did not.
That's funny.
And she was one of my, she wrote one of my letters of recommendation, right? The school secretary. And of course, the teachers and the counselors and stuff. And I went to one of those college fairs.
Yeah.
The dean of admission came to Trinity University, and I went and I met her. I just fell in love with the university. I fell in love with her, and I'm glad I went. It was hard.
Catholic small town parents feel about going all the way 10 states away to the liberal West? Like, that's crazy.
Well, I've always been, I guess, a little liberal for my family.
Fair, been there.
It's, it it was interesting. I remember a conversation with my grandfather, my paternal grandfather, and he was talking with my dad and was just like, why are you, quote unquote, letting her go? She doesn't need to go that far to get married, kind of thing.
Yeah.
And it was a testament to my father, who is a big proponent of education. It's like, if that's where she wants to go, that's where she's going. And I'm glad he had that position. Not just my senior year of high school, but he and my mother were very much big advocates of education. I really and I wholeheartedly believe it. Right, I've bought into it. That is really the opportunity for coming up in our society.
Oh, for sure. I would agree. Well, that's amazing. Did you go right after high school? Like, did you, like quote unquote on track?
Yes.
Okay. How do you do that? And then why engineering? Like where was your mind at then? Because from an engineering to family lawyer to civil district judge is
it's a lot of different lives, right? A lot of different lives. I wanted to make sure that I had a job when I finished college, right? That was the big thing.
I'm laughing because I did philosophy and religious studies, so I didn't. Sorry, go ahead.
Right. No, I love it because it made a difference in being employed and having internships during the summer.
Okay.
And I enjoyed it. I was really good at math in high school. Once I got to Stanford, I appreciated that there are so many different high schools in this country, and some of my peers came in my first year calculus class. They were on a different page.
Different, like a higher level.
Higher level. Just it was night and day.
Was there a big international presence when you were there? I would imagine.
I don't know if it was big.
Okay.
The campus compared to Catholic high school, the campus itself was big.
Oh, well, imagine.
So, but no, I didn't. It didn't strike me as anything more unusual than anything else.
Okay. Yeah, I went to a college football school. No, we had fun. So you had a 2-year gap between then and law school. What'd you do those 2 years?
So I was in aerospace engineering. So I was working in the shop floor, doing operations, quality improvement, process improvement, working with suppliers. I also worked the repair and overhaul line. So really getting the shop floor ready to take different repairs and still get them out the door as quickly as possible. And like pseudo management, between the shop and the management team, I was working those communications as well. So it was Honeywell.
So
it was Allied Signal, and then we got bought by Honeywell, or we bought Honeywell and took their name because they had more market recognition.
Okay. So you say you want a job. You didn't have a job, you had a career.
I had a career.
I mean, that's not like, you didn't like become an electrician, which is a great career on its own, or a whatever, like there's a full-on career. So, I mean, all right, well, I got to ask, like, how do you go from there and say, I want to be a lawyer, and then why Seton Hall?
I always wanted to be a lawyer.
Okay.
So I remember watching The Paper Chase. I don't know.
Yeah.
I think I'm a little bit older than you, probably a lot more than just a little bit. But that was a series that was on, and I would watch that with my father, and it was just amazing to me. I wanted to be a lawyer since, I don't know, 3rd grade, 2nd grade.
Okay.
But I wanted to also go through college, work, pay off some debt, and then go to law school. That was my plan.
Mm-hmm.
And engineering, I love being an engineer. So I was in industrial engineering management, and I just had so much fun with that. Okay. If I could do both, if I could have worked both careers in parallel, I would have gotten my professional engineering license and stayed in that field.
Not too many overnight judges, I guess. You could work your day time as an engineer. I don't know how that would go. I guess you could do mediation.
I thought about it. Yeah. Well, yeah, I thought about it.
Okay. So that was somewhat planned. I mean, the track was planned. I want to go to law school.
The track was planned.
Okay.
And as far as Seton Hall, I just wanted to go coast to coast and then come back home. Like wow. I think, we have, it's a little bit less appreciated, I think, in the current climate. But I think there's so much to be gained by getting different perspectives, even within our own country.
Oh, for sure.
So.
I mean, I want to mess up the phrase, but it's you're as smart as how well you've read and how well you've traveled. Is what I've heard, or something like that. My dad would say, you're only as smart as where you've been and what you've read. So, and I think economics play a role in how much you get to travel. I get that, but No, I agree. Both domestic and international. It's funny because you'll get. I shy away from politics in general, but you'll get like I love my parents, but way more on the conservative side, evangelical. And like my dad will say something like, "There's no way that many people voted for that person." And I'm like, "Dad, I promise you, in the cities where I'm at, they're like, how did anybody vote for that person?" Like, it's funny how disparate the world is, even in our own coast. So yeah, okay. So I wanted to get to the judge stuff, but I actually didn't know most of that about you. So
Oh,
that's pretty
okay.
cool.
Well,
Yeah.
good. See, we're getting to know each other.
Yeah.
Even more.
Even more. I've practiced in front of you since you've been on the bench, if I remember right.
Yes.
Yeah. So
And we used to practice together or against each other.
we did. I don't know. Did we ever have a case with each other before you took the? I don't remember one.
I don't know, to be honest. I remember us being and presiding together as practicing lawyers, but I don't remember if we had a case opposite each other.
Good memories, I hope. I don't know.
Yeah.
Different time in my life. That's
Yes.
okay.
No. Definitely good memories.
Okay. So you graduated Seton Hall. You come back. What did you do to first start practicing here?
So I came back to Texas, my path home, if you will, with the federal clerkship.
Oh wow.
So I spent 2 years as a federal law clerk for Judge Clark, who was at the Eastern District
Okay.
of Texas, Beaumont Division, and then we would go also up to Lufkin. So the way the federal judges in Beaumont did it is they took cycles. They took a part of the docket in Lufkin because there wasn't a judge that was assigned to Lufkin at that time.
Okay.
So I was there from 2003 to 2005. And then I went to Dallas and did some products liability defense, representing General Motors, Toyota. And then I had interned at Texas Rio Grande Legal Aid. It was Texas Rural Legal Aid at the time.
Mm-hmm.
And so David Hall, who was the executive director at that time, I met up with him at one of the state bar conferences, and he's just like, "What are you doing in Dallas? That's
Sure.
not where you belong. Come back home. Not just home to San Antonio, but come back to the nonprofit," because I really enjoyed my time.
I gotta ask though. I mean, like that's a real, like, for people who don't know, federal clerkships are sought after. Like that's not a, like the same way I'm giving praise for getting into Stanford. Your grades must be impeccable and stuff like that. Like federal clerkships don't happen on accident. Like they're sought after, letters of recommendation, and my understanding, most people doing that are looking for federal appointments and or a federal bench later on. So you go from there. If you're doing products liability defense, I have to imagine it's a decent sized firm making decent sized money, or at least on track to do that. So why go there to nonprofit?
So my heart has always been in service, right? Even undergrad, a lot of the things that I did at Stanford were for the betterment of the community. A lot of tutoring, a lot of education, a lot of tours. So my heart has always been in service. And I went to law school thinking that I was actually going to be working with MALDEF and doing education reform, litigation, doing that kind of courtroom work. And when I went to Texas Rural Legal Aid and spent a summer doing family law, it opened my eyes, right? Like I think the way to effectuate our community, family at a time, is to set the stage so that way the litigants, the people who are going through, in my case, when I was working at Texas Rio Grande Legal Aid, getting past some of the most horrendous times of their life and still having to parent, right?
Yeah.
I represented the majority of my docket were parents who were also victims of domestic violence. And so once we got past the protective order litigation or that initial temporary orders hearing, they still had the rest of their lives to try to parent together with the person who had caused them harm. And sometimes caused their children harm, physical harm. So I think in service is why I came back to Texas Rio Grande Legal Aid.
That's a real, I just wanted to highlight, that's a real sacrifice. I mean, you may not view it that way if that's where your heart is, I understand, but like, you've got 2 young babies, right?
I do.
Yeah. I mean,
well,
so
they're not as young as
young.
they were. Yeah. No.
But we all have needs, we all have knots or responsibilities. So I'm applauding that, but also just curious into that. Is that hard to, I'm getting to the part talking to you as a judge, but as someone who been a public servant with legal aid, not ever going to ask numbers, but a more modest salary than colleagues privately done, who exist privately. And then as a judge, again, I tend to advocate, I think they should be paid a lot more. That's just the opinion I have. Again, not a complaining salary, but again, modest compared to some of our colleagues. Is it hard for you to look at guys like me and others that are pretty shameless? Like, I'm here to make money. I mean, I advocate for my clients, absolutely, but I mean, we have an interest in business. Like, is it hard for you to relate sometimes to people that are a little more capital minded?
No, because so I'm the oldest of three, and
Okay.
so my two younger brothers are in Austin, and my oldest brother, the middle child in our family, I mean, he's very business minded, right? He went to undergrad, he got his business, and he's been an entrepreneur even while we were in undergrad.
Oh wow.
And so I appreciate that's what gives him fulfillment. My youngest brother, I say my baby brother, but he just turned 46. So my youngest brother, he's a firefighter, right? So his space for service and his call and what gives him fulfillment is a different kind of service, right? Like very much hands-on. He's the guy that's running into the fire. Right, I'm not going to run into the fire unless my kids are there.
Just a media fire.
Right. Well, I do that often, yes.
We'll get there. It's okay. All right. So 15 years at Legal Aid?
No. So 15 years litigating.
Okay.
The majority of my career was at Legal Aid.
Okay.
And then to your point, I did have to leave. And I had my own firm. I was an associate with Lisa Vance and D.D. Whitley for a little bit.
Okay.
And then when their firm split, I stayed as an associate with Lisa Vance.
Okay.
And then I had my own practice during my first campaign.
Okay. Excuse me. I apologize. I'm drinking the soda here.
No, that's okay. So,
when you were with, is it now Rio Grande and then it was rural legal aid?
it was rural when I was in law school. And then they had that, I think it was in 2001, the legislature combined all of the legal aid, the LSC corporations that were here in Texas into, I think, 3 or 4 different entities. So Texas Rural Legal Aid combined with Bexar County Legal Aid, combined with whatever legal aid organization was in Corpus and Laredo, and all the way through El Paso.
Okay.
So now Texas Rio Grande Legal Aid is that combination of quite a bit of legal aid organizations before 2001.
I get this question often, so just to help people
Or maybe
out.
it was 2003. Maybe, I don't know. One of those.
I get the question often about people seeking that kind of help. And my understanding, please correct me, is the majority of that starts with domestic violence cases, how you triage who gets the opportunity to use your services. Is that still correct? It's usually domestic violence and then protective orders that the DA maybe is conflicted out of and they can get to that? Or how do you get those services for people who need to use Rio Grande or these legal aids?
So each organization has their different qualifications, but as far as I know, TRLA, the Texas Rio Grande Legal Aid, the majority, if not all, of their family litigation is for victims of domestic violence.
Okay.
And that's tied to need, it's tied to funding, it's tied to, limited resources with the highest impact litigation. Mm-hmm. And Texas Rio Grande Legal Aid, it's a multi-service law firm. It's a nonprofit law firm. So they take federal cases.
Oh, okay.
They take employment cases. They take, I'm blanking. It's the climate stuff.
Oh, okay. Environmental.
Thank you.
Okay.
Oh my gosh.
That's all right.
And then they've got immigration practice. They have public benefits practice.
Okay.
It's quite a robust nonprofit law firm.
All right. And your role was primarily with the domestic violence, so the protective orders, and did that bleed into actual family cases? Like when I say actual SAPSers and divorces, like you did those as well with them?
Oh yes. So
Okay.
I did protective order litigation. I did divorce. I did SAPSer. I did CPS.
Okay. When you say you did CPS, like representing parents, children, the state?
When I was at Legal Aid, it was parents.
Okay.
So there were times where my client was not only trying to divorce her husband or litigate the custody issues against their partner, but I was also defending a case against the state.
Okay.
And so obviously she was entitled to an attorney, an appointed attorney in that 262 case.
Right.
But sometimes I would just substitute in, or sometimes I would co-counsel with whoever the court had appointed.
Okay.
And especially if they were getting close to the end. right? And if there were some issues regarding the expertise, understanding the domestic violence dynamic, then our firm really brought those resources to the table.
That's important. I don't know if people fully realize, but I think a lot of women get trapped in they're the victim of domestic violence, and then the FPS will step in and saying, fairly or not fairly, you're a threat to the kids, mom, because you let the domestic violence happen, and then they get kind of swept into the CPS case, and then the kids get removed. And so I'm not saying that all are innocent or aren't innocent, but they get in that situation. They're victims almost all around, and now the state's after them, and the guys after them. And it's pretty rough. So that's a tough place to navigate. Did you ever take appointments for the wheel, for the CPS wheel itself?
Here in Bexar County?
Yes, ma'am.
Yes. After
Okay.
I left legal aid and after I was on my own, I had my own practice.
Okay.
I was able to take those appointments because when I was working with the boutique law firms, at the time, pre 2019, I think our pay was $20 an hour,
Nothing.
$25 an hour. Right. And so, being a firm and having overhead,
Nope.
there was just that wasn't going to be sustained. But once I had my own practice, I essentially split my docket in half, and I had half private pay and I did half court appointments.
Okay.
And in my mind, that's how I reconciled being in private practice, right? Profit driven,
Okay.
and also still maintaining my community service.
All right. Well, here I'll be candid. I haven't taken appointments in years. The
Well,
money's
it's $75 an hour now.
hard. Well, and again,
I shouldn't laugh, but
no, it's okay. And for the reason we're laughing is it's 75 feels like a lot, but I'm not first world problems. We're both blessed. I mean, candidly, we're both blessed. We won't ever get dollars out, but I'm not complaining about income. You're not complaining about income. But the person they'll hire will be at the low end 275, 300 up to 350, 400. That doesn't mean they bill every hour, and that 350, 400 doesn't go in the lawyer's pocket. It's overhead. But the chance of getting a Mary Lou Alvarez as your advocate when you're taking appointments, who has the real heart for public service, somehow has managed finances to where they can still do the process well as an advocate, is low in my mind. I think a lot of people take them early on because it's a place for income. So with relatively low experience, which is fine. You need to get experience. Doesn't mean they're not passionate advocates. I candidly struggle to see a lot of passionate advocacy when I see the children's courts. I get cases after the fact retained, the 262s happen, and it was agreed to, and I'm just throwing the papers on the wall, who would agree to these things? It just drives me crazy. I mean, I probably drive y'all crazy because I'm de novoing them all to y'all, and you're like, Beau, why do you just agree? But it's amazing. So they're lucky to have had you, but they need to pay more to get more. And I don't know where the funding comes from. I know we talked about this off camera, but I think it puts practitioners in a bad position because they run those children's court dockets. They'll have 6 262s for the whole afternoon. Dude, mine take 2 days. No,
Right.
and I don't have a good answer, but anyway, that's why we're laughing at 75 an hour because no, not going to do it. So anyway, all right. How long did you practice on your own?
I practiced on my own, I want to say between about 2 years, 1.5 to 2.5 years.
Okay.
I'll just land in the middle.
Sure.
Yep.
And was that with anticipating running for judge?
Yes, for the most part. I had before, when I left legal aid and before I was a full-time associate with Vance and Whitley and then with Lisa Vance, I had a time where I had my own practice and I was kind of doing contract work for them and then having my own practice. So that was probably about, 6 to 9 months. I had no idea I was going to run for judge. But once I was an associate attorney and I decided to not be an associate attorney and be a business owner, that was with an expectation that I wanted the flexibility to run for office.
Okay.
And I was looking, at that point in 2017, I was looking to the 2018 election.
Did you pick these benches? When I say these benches, are Bear civil district courts because of your passion for family law? Because that's where we have our family law here in Texas or in Bear County.
Yes, and those were the benches that I practiced in front of.
Fair.
Right. So when
Okay.
I came back home to San Antonio home in 2006, those were the courts that I practiced in front of. Now I practiced in surrounding counties,
Of
and
course.
sometimes like
Yeah.
in Medina, you're practicing in county court, not district court.
Yeah.
But for the most part, here in Bexar County, I was practicing in front of the state district courts.
Okay. Yeah. So what made that decision? Is it, again, public service, or what? Why go to be a judge?
So it was unbeknownst to me at the time, right? My expectation is that I could effectuate and help more families in an 8-hour day than I could taking one case at a time.
Fair.
Right. And so that has remained true. But the expectation that it was just going to be 8 to 5, that is not correct.
I think it could be if you want it to be, and that's on you. Right?
And it could be, right?
Yeah.
You're right. But I've grown into my judicial career understanding and appreciating that the service is on and off the bench.
Yeah.
Right. And that the work that we are asked to do isn't an 8 to 5 work.
Right. Well, I mean, let's go ahead and go there, because I have a lot more questions in this initial part. But what she asks, what does your typical day look like? I do have an idea of what your 8 to 5 looks like. I'm in front of you a lot of it. What does the rest look like for you? So what does a work week look like for you?
So a work week, it's so different because I'm also a parent, and I'm a single solo parent. I know people appreciate that their singleness is tied to their romantic status, but I'm a solo parent. I'm a single mom by choice. I live across the street from my parents, so I'm not going to discredit them at all, because they help me a lot. In fact, my grandpa is the main chauffeur during the week.
Oh, cute.
So he's the one that my kids rely on to be there to pick them up and take them to practices and that sort of thing. But a normal work week, my first job is to get the kids to school, right, and get them fed and get them situated, and of course dockets start at 8:30, and I'm there. Lunch meetings probably 4 out of the 5 days of the week. Community service, community events, especially now during campaign season, those are taking up probably anywhere from 3 to 5 nights of the week.
I would imagine.
And that's usually from 4:30 to 7:30, 5:30 to 8:30 in that time frame. And then sometimes I just have to not do that and go watch a basketball game or watch a soccer game, because I don't watch all of my kids' sporting events. I don't want anybody to think that I am somehow in 5 different places at once. But I don't like more than a few of their games to have passed before I see one.
Fair.
Right? So I'll see one, then I'll probably miss a couple, and then I'll be there by the time the third one comes. But that's just me.
Yeah.
And so that also happens in that same time frame, in 4:30 to 7:30 time frame. And then we get home probably between 8:30 and 9. My kids and I go to sleep late every night during the school week, which is I don't recommend, but I understand.
Yeah. Life's. It is what it is.
Life's life, right?
Yeah.
And if we were to go to bed at 9, I'd see my kids for like 5 minutes.
And they'd see you for like 5 minutes. Yeah, that's not. Yeah.
Right. So we usually have time to relax at home, check in on homework, see how things are going. Sometimes just all 3 of us are vegging out watching TV
Nothing wrong with that.
from about 9 to 10:30. And then 10:30 we start getting ready for bed, and they're in bed around 11. Sometimes it's 10:55, sometimes it's 11:15, but around 11.
Sure.
And then I get up at 6, they get up at 6:30, and then we start over again.
There you go. How much time away from your 8 to 5 do you have to spend if you're getting like a summary judgment packet with a lot of law, or if you take a ruling under advisement, or maybe if you're researching an issue that was presented and 2 counsels had very differing perspectives? How much time away from the bench do you have to spend on those kind of things?
Depending on the week, it could be anywhere from 5 to 10 hours.
Okay.
And I try to minimize that. I'll be very candid.
Sure.
Part of what drove me to the bench as a way of service was also my expectation that I'd be able to balance the career and my parenting a little bit better than if I were an entrepreneur or had my own practice. That hasn't necessarily been the case, but I do try to minimize how much time I'm reading on a Sunday night.
Fair. Yeah. And you have, I mean, I don't want to speak for you, but you have staff attorneys that part of their role is to help you with that. Is that fair to say?
It is. Our staff attorneys have been given so much, though, especially in this like COVID, post-COVID era. They became a lot of the administration and a lot of the technical
Okay.
capability, and especially now with the e-filing submissions, right? A lot of their work now is administrative coordination and sometimes even clerk type things that you would
Okay.
expect the clerks to do.
Yeah.
So the legal analysis, right? Like, and I'll be very candid. Part of what I think was missing supporting my court 2022 through 2025 last year was having the bandwidth, the legal bandwidth to have some appellate work appreciating and defending the court in the fourth court.
Okay.
And we can't, we've got 4 staff attorneys now. For a long time, we only had 3. For a
We have-
little bit of time, we only had 2
So
that
4
were
staff
shared.
attorneys shared between 14 district judges, and does that include 2 child support judges and 3 children's court judges? Do they work for them as well?
I mean, technically they do, but I don't know that our associate judges even have a space to make a request,
Fair.
right?
Good
Because
grief.
it's pretty thin.
Yeah.
And then we've got one general counsel who is serving all 14 state district judges, and then our 3 associate judges on the CPS floor. Our child support associate judges are kind of standalone.
Okay.
They're Title
4. Yeah.
IV courts. So I don't know if they've availed themselves of our general counsel. I don't even know if there would be like a little dotted line to him.
I mean, pragmatically, I don't know. That's not a shot at them, but their way their role works and how their cases are, I don't think it would merit some of the work the staff attorney would do. Like, they're not getting a complex litigate. Not again, it's not a shot, but
It's a volume. It's a
Right.
volume bench.
Right. Yeah.
Yes, it's a volume bench, and our like you said, our state district court benches are more nuanced and complicated at times.
And for people who don't know, like when we say state district court, and because we're a big enough county, our county courts don't handle these. So every family case, any litigation case over $250,000,
Yes.
but also you can do less than $250,000 in a district if you want there. And so that's any lawsuit. That's contract. That's a tort. That's anything I think of. Foreclosures. I have a foreclosure in front of you. Any of the above. So
Easements,
yes. Yeah.
injunctions, like some of the civil matters that kind of are newsworthy.
Yeah.
Right? The injunction that we just had against the city of San Antonio,
Mm-hmm.
a lot of government litigation.
Well, when COVID first came down and there was a lot of fight of who can do this, what's emergency, what's not, a lot of that came to y'all's doorstep
Right.
there. So what percent is family? Actually, never knew.
I've heard, being on the campaign trail, it kind of gets tossed around that it's about 80% family,
Sounds right.
20%. And just, generally speaking with the 80-20 rule, that sounds about right too. But I've never gone to the district
fair.
clerk and
Yeah.
said, can we run some numbers here? Can we run reports? But I think what's widely accepted is about 80% of our docket is family litigation, and 20% is other.
Okay. And it's just, when you say other, that's amazing though, because that's extremely $1 million complex litigation, every car wreck. And then they might sound run of the mill to some people, but that's experts for medical malpractice. Attorney malpractice will go up there if it goes past a certain stage. So it's a whole lot of volume. No human being, I don't care what kind of lawyer you are, knows every law, knows everything that goes up there. I would assume y'all are the most familiar with family law because that's what you deal with day in, day out. But even then, you're probably once a day, once a week. I don't know the answer to that. Or what does the law say? I would assume. I don't know. Is that where you're at? Or
Once a week, with the caveat that some of the questions are easy enough to just pull up the code, right?
Sure. Yeah.
Right. Like some of these things are, how our legislature meets every 2 years. They're tweaking the family code here and there. So some of those things you can look up, and that question gets resolved pretty quickly. But I'd say probably about, I don't know, maybe once a month, once every other month, there's an issue where I really need to spend a few hours trying to appreciate where the boundaries with the case law are, right? Either the case law is new and it's developed, i.e. what our fourth court did with our CPS litigation from 22 to 25, or there's something that hasn't come up before, and I need to spend some time figuring it out.
So I'm going to go backwards a little, but I want to lean into somewhere. People ask, you ever want to be a judge? No. I mean, candidly, I've got some bar history. I had substance abuse in the past, and I don't want to deal with the campaign with explaining myself. Two, I like the money that's typically away from it. Not every year, but it's easier for me. And what's funny is I feel like my work-life balance is a little easier on my own, without the strictures of your 8 to 5, because you don't really have a choice. I don't know, but I think as someone who's accountable generally, I've got to be there when I've got to be there, so, at least 8 to 5, Monday to Friday, you can't be somewhere else. So, but the real reason, among the reasons I want to be judges, I advocate for a client, good, bad, or ugly. They pay me. I'm not gonna lie. I'm not gonna support perjury. But outside of that, the rules for me, they are what they are, and I'll put it to a judge without being dishonest, and try not to be too intellectually dishonest, but do the best to get a result, and the results are going to be what they're going to be. And if I've done my job as a counselor and gave them the range and a likely outcome, it is what it is. So my impact is, I don't think it's insignificant, but it's targeted, to my client. Your impact's different because your decisions will affect people's lives. Not that I don't, but way more. You got me and a colleague just like me coming at you, and your decision affects how the parents are, the kids, their safety. I don't want that weight. So how do you, when you go into a campaign, how do you balance, or how do you process that, I guess, and process it after doing it for 8 years?
So I think the processing of it after the experience, I don't want to say easier, because it's okay. Not insignificant, but I think, like the practice of law, the practice of judging, I think you get better at it with time. And I do think that my judicial career has been similar in that it's been a practice that I've improved continuously. And I've been better to navigate the consequence of my decisions by trying to deliver them in a way that's easier to receive than back in 2019. I don't think it's a secret that I was pretty rigid. And I think I lean rigid, right? Not maybe because I'm a Virgo, maybe because I'm a solo mom, maybe because I'm busy, maybe because I'm thinking fast. I've had to slow down to make sure that the way I'm received is the way I intended to be received. Sure. And so I think that helps. I think my responsibility to the institution has also softened with its rigidity, right? I think, as we all are, right, officers of the court and judicial officers, and especially in this political climate, I think we've got a really strong pull to defend the institution. Okay. Because this is, I obviously am biased, but the judicial institution, it's the institution that people most interact with, right? Coming with everyday problems, seeking everyday solutions. And it's the institution that is most vulnerable to its decisions being complied with, right? We don't have an army. Mm-mm. We're not out there seeking enforcement ourselves from the bench. We're relying on litigants to hire lawyers, or litigants to file the appropriate paperwork to bring problems to our attention. So we are very much vulnerable to people hearing the orders, following the orders, because that's the right thing to do. Mm-hmm. And in that back and forth, that's how chaos is kept at bay. And I think back in 2019, I came with this expectation that everything was going to work 100%, not realizing quite the way I realize now, 8 years later, that the back and forth and the buy-in takes a softer approach. Mm-hmm. Fair. I don't even remember your original question. That's okay. I'm sorry, I started talking so much. You're fine.
No, that's the point of this, is to be fluid. But the original question is more, in any way you want to handle it, the gravity of your decisions. at the end of the day, you don't, maybe you think you do, I don't know, really know how it's going to pan out. To a lazy example, not a real case, but a made up, gentleman accused of domestic violence and the protective orders in front of you, a non-jury bench trial. And whatever, make up the facts you want, but there's some uncertainty. The guy seems credible. He had me. I'm a great advocate, but you have a complaining witness that has some credit. And at the end of the day, you're going to make a decision that says, I'm granting a protective order. This guy no longer can buy a firearm the rest of his life. He now has a finding of family violence. God forbid, accused again, it's a felony. He's going to have trouble with the presumption for sole managing versus joint managed conservatorship, and just a mar in general. It's a beat down on this guy. Or you're going to say no, and then now is this lady at risk? You got to sleep at night. You made one or the other. That's kind of what I'm asking. Like, how do you manage that? Because again, I don't care how, and I wonder if having good advocates makes that even harder for you. That'd be a different question. But so I guess the first question is, how do you manage the gravity going into being a judgment more at 8 years, going to sleep at night? I hope I got it right, And then I guess the second question is, do good litigants make that harder on you?
Those are great questions. So it is a lot as far as like the weight of the decision, and we do it so often, right? We are doing it so often,
especially in Bear. I will say that, but sorry, go ahead.
In Bear County, yes.
Yeah.
But I think what has made the weight of the decision and the consequence of the decision less heavy is the faith that the institution is longstanding.
Fair.
Right? Like this, if I didn't make this decision, what would happen? Right?
Yeah.
If there weren't parameters, if there wasn't an expectation that was on paper, right, with our court orders, that both people can look at and follow, that law enforcement can look at and follow, that the community can look at and follow, what would happen if that wasn't done?
Yeah.
Right? And so I think the opposite of the decision is almost heavier, which makes the decision easier to carry.
That's fair. I didn't even think of that. So yeah.
Yeah. And so with protective orders, all of the cases are important. Every time an allegation of domestic violence is raised, it's important. Every time an allegation of sexual assault is raised, it's important. And each of them have their own weight as far as making the decision and assessing credibility.
Yeah.
Right? That's the other, I don't know, elephant in the room, right? Mm-hmm. And as a lawyer, you don't know which side of your client, at least what I remember when I was litigating cases, 2018 and before. Sometimes you don't know which version of your client is going to show up on the witness stand, right? Because people are human.
Yes.
Yeah, because it happens all the time. Like sometimes I've gotten better about this too, because back in 2019, I was just, and that was my first year on the bench. I was just be like, why didn't this lawyer prepare their client? And now I can appreciate that the preparation probably happened, and it's just human, right? Yeah. It's just is what it is. Sometimes, people's flaws are showing more than other times.
It's funny, not funny. It's a thing when you believe your client, but they don't come across as credible, and you're just like shaking your head. And the best I can do, I guess, is I get in front of you or one of your colleagues and just be like, okay, you're going to have some second thoughts here, but hear me out. Like, hear the whole thing. Like in a jury, just like, I need you to wait till the end. I promise I'm getting there. Just, you're going to have to hold on for a second.
Yeah.
But yeah, I do like the idea that good advocates can make your job harder, not easier, but that's funny to me.
They do.
Yeah.
They do. But, it also makes it easier in that good advocates are laying out the alternatives explicitly.
Yes. Yeah.
Right? And where the credibility flaws has already been highlighted. What the ramifications of the decision are kind of like extrapolated, maybe speculated. So if there's room to avoid something, you can do it because you have it laid out.
Yeah.
Good advocates are important.
I want to go through some of her questions, and then I have some big topics to hit. What she says, what do judges focus most on during hearings? I guess, what do you focus most on during hearings? So maybe some things people don't think of. When you're going into a hearing, you can make up whatever kind. What are you looking for?
Well, obviously preparation, but
Yeah.
I'm looking for sincerity.
Okay.
And I'm looking for things that make sense, right? So if I'm listening to a narrative, in my mind, I hear loudly when things aren't going as expected, right? So, for example, and this is just an example that's kind of like gathering of different things that have shown up, right? If you're banging on the table about tardies, and then you tell me the child at issue is like a straight A student, National Honor Society. I'm like, well,
Which is it, right?
I mean, or it could be both. And if
Yeah,
it's
sure.
both, then maybe the bang on the table for the tardies doesn't have to be quite so loud.
Or the attorney should have said, Judge, I know they're doing well in school, but this has become an issue. Like, at least address it up front, right? Like, yeah.
Right. And why is it an issue? Like,
Yeah.
are they missing an opportunity to be in student council? Are they missing an opportunity to get the practice of doing morning announcements? Are they missing an opportunity to be in ROTC? Like something that's particular to this case, rather than relying on me to be like, oh,
What?
tardies are bad, therefore let's restrict rights.
Right.
Right.
Easy supervised. Yeah.
Yeah. It's got to relate. It's got to be, the requested relief has to match what the allegations are.
I want you to scream that, because it's hard on my end, because my favorite potential clients when they come in are like just clean whiteboards. It's like, and that way I can ask the question, what do you want, or what's best, rather than, well, here's the law and property division and you should get, like, stop. That doesn't mean I won't give it to them, and it doesn't mean that it's not the right. And certainly with kids, the worst comes in, they've used ChatGPT and they come in like, I need supervised and I need SOL and I need this. And what happened, she was a stay-at-home mom and dad worked a lot, and like, he doesn't know how to put a car seat in, but like they co-parented together. Like, what do you want me to do? Like, I mean,
Right.
like the guy's just a dude. I'm not saying he's but they've already got a preconceived notion because maybe another attorney gave him a consult and said, here's what we can do for you. Like, no.
Their AI bot was off on their predictions.
Oh my gosh. Yeah. So
I'm sure it's a different world practicing law in the age of AI.
it's what you make of it. Like, for me to complain, again, first world problem. I don't use it for anything outside of Googling occasionally for whatever I want to look at. But I was in a hearing in Dallas or Fort Worth County, and the client said, "So do you use ChatGPT to prepare?" Like, no. He's like, really? Like, no. Like, it's gonna get it wrong, man. Like, what are you doing? Like, I'm good. It's amazing. Google's the worst though, because people just get a misconception about what's available or what's appropriate. And then the other part is just they talk to their friend who had a different result. Like, it was a different case, different time, different judge. The law might have been different. I don't know what to tell you. I mean, I don't.
Right.
So okay, but that's really good. I do want to hear people scream. The relief has to match like the evidence. Like what are you
Right.
asking for? It needs to be related to that. And I do get that a lot on my end. Tardy, or he yelled at me on the app close. He needs to be supervised. Like, no. I mean, I know how you feel, and I do want to give credibility to people. Like, that doesn't mean they're malicious or dumb, but no, like, that doesn't affect the kid, or it does. I get the other side too. Like, I was just drinking. You were drinking and driving with a kid, man. Like, what do you want me to?
Yeah.
Like, come on, buddy.
But what, and this is something that I'm trying to remind myself, that in that space where the parents were together, that lifestyle may have been acceptable, right? Like, not necessarily joint. I'm not saying that, only people who have problems with drinking are only procreating and like in a romantic relationship with other people who have
Right.
substance abuse issues. But when they're together and there's not a stage to fight, okay, if you went down to the right, not okay from the society or what we know about child safety, but okay between parent one and parent two.
Yeah.
And now the stage is set up to fight and to litigate, and now everything is a problem. And you just need to get through that space.
It cuts both ways too, right? Because on one end, yeah, you're now both single parents, however, like not solo, but you're both single parenting at your time. Yeah, you can't go to the bar on the way home from work, man. Like you got your kids on Friday night, and ma'am, you can't complain that he drinks. You were fine leaving the kids alone with them forever and ever. I don't mean to excess. I don't mean extremes, but like I said, it kind of cuts both ways. Like, you don't get to hold him to a standard you didn't a second ago. And sir, well, go ahead.
That's right. No,
Yeah.
that's exactly right. You don't get the partner you weren't married to because you want to blaspheme that person in front of a stage.
I like this question. I have some ideas of your answers, but what separates effective advocates from average ones?
Preparation, yes, of course.
Sure.
But Judge Ray's gave me a compliment when I was practicing in Atascosa County that I hold on to. And it was after I had not prevailed.
That's a little bit of a less compliment, but okay.
So it may have been a tongue in cheek, but I don't think it was intended to be. She's like, you really know your client's circumstances. And as a family litigator, like that takes time. That doesn't get, like the time that you invest to know this client's circumstance and facts and life, that doesn't translate to the next client because they're different.
Yeah.
And so for me, what separates an average litigator from an excellent one is the one that took the time, that already knows the law, right? Like that's
Sure,
the
yeah.
stage. Everybody knows the law. Everybody knows how to look it up on the family code if you forgot, whatever the guideline support was for 10 kids. But
Yeah.
everybody can look it up, right? It's the litigator that themselves or some system with their staff really knows the nuances of that particular client's case.
I like that. I think also authenticity with the court, I think matters a fair bit. I don't know. I guess I would
Yes.
ask.
No, absolutely.
This isn't me asking for pats on the back. What I try to do is be upfront with the court about who my client is, what they want, and where we're going. That sometimes is hard if I'm asking for relief that may not make sense with those facts, but that kind of is a different. But I think inauthentic, because I think if you're just inauthentic in what you're asking for, because you already said it, like if it doesn't make sense, like what are we doing here?
Right.
So if I'm candid about why is this the best, like I know he did this, but actually he is more appropriate for primary, please hear me why, and at least try it. But I think if I'm authentic, I address the flaws closer to the front than the back, and put you in that position, I hope is a good way to do that.
Yes.
Yeah. Do you have, what, I do want to get here and we have time, but our system is, we call it a presiding system. I think there's only one more in Texas.
Well, that's funny because I know that's what the headlines say, right?
Right.
Like Bexar County and Travis County are the only ones. But like I mentioned, one of my contiguous counties that I practiced in was Atascosa.
Mm-hmm.
And Judge Ray's and Judge Saxon switch benches all the time.
I think they still do that. It's not Judge Ray Saxon. It's Judge Wilson and very nice lady. She's wonderful. I say new, probably in her second term now, but I'm getting old.
It's okay.
So you're not wrong. Like there's a hint of that elsewhere. It's very prominent here. And then I'll describe it like we have 14 civil district benches, 5 associate courts that are specialized. And rather than you're the 45th district, you live in this geographic area or like a tiny one, or you're assigned the 45th court, and then you have to go to Judge Alvarez's clerk or coordinator, and you have to schedule everything through Judge Alvarez. If you're in Bexar County, you can just simply go to presiding court, whatever court your case is technically in on the paper, and you can have hearings basically anytime the court is open, and make them available.
Right.
Excuse me. Sorry. So that's been the case since not the recently late Judge Casa, but his grandfather?
His father.
His father, excuse me.
I think his father.
Yeah. 48, 52, something like that. 58, 60 something. 50, 60 years.
Somewhere around there. I should know, but I don't.
Fair.
50,
But-
60 years.
Yeah, but past both our lifetimes. That's how we do it here. And that is, I don't know if the Supreme Court is still deciding whether that's even going to, I think that's what's happening right now. But two of your colleagues have now opted out, which I guess is available to them now, because I know there was an attempt to do that last year. But I guess it's available March 1st. What are your thoughts on a presiding system? Does it work? Does there need to be a change? Where do you see it going? I mean, just kind of in general, where are you at with that?
So I appreciate the presiding court system's access to justice focus,
Yeah.
right? And I think people need to hear that. And I think our Texas Supreme Court needs to hear that when they want to, as obviously our highest court in the state, want to start micromanaging trial courts. They are, in essence, deciding for each community what is supposed to be important for them. And I don't think that's the way our design was set up to be.
I agree.
And so, like you said, for multiple decades, 6 decades, 5 decades or more, for sure, our community has decided that having the courthouse doors open is our highest priority. And I don't think that was wrong. I think people, especially people who have family law issues, need to be able to access the court when the court is open.
I want to interrupt to say, when we say that, there's a presiding judge sitting there 8:30 a.m. to 5 p.m. daily, and now with remote Zoom, if you need a temporary restraining order signed, a temporary protective order signed, if two lawyers can't agree on a continuance, if we want an agreed judgment signed, we want an agreed divorce proved up, I can Zoom in or walk into our courthouse and get it done. So that's access number one, is the second I want it, it happens. Number two, I can, if it's open and you guys haven't like capped the day, but just generally, I can basically, if it's not a court holiday or a weekend, I can simply say I have 3 days notice, 10 days notice, 45 days notice on a wherever the rule is, I can set the hearing that day. And so if I have a colleague of mine that doesn't want to confer on court dates and not answer emails, Adam Wheeler, I'm teasing completely. Because I
thought, Mr. Wheeler, I'm not signing on to that. No,
Because I've done it to him on a mediation lately and he's mad at me. No, and they don't want to do that. I can set the thing and then we can confer after that, or I can bring it to a court's attention. Like, okay, I didn't confer, but he wouldn't. I can do those things. I have no restrictions as a practitioner to getting my client in front of the court, whether it's off docket or on docket. So I want people to hear, like, you say access to courts, it's open.
Right.
I had a Christmas break in Kerr County, and I don't want to disparage anybody there. My client didn't get access. I filed a writ, couldn't get a hearing. So he missed his whole Christmas break. Now, we have the enforcement set, great, but that time's never coming back. That doesn't happen here. I would have had now, win, lose, or draw. Maybe it was justified. That's not important. The important thing is it would have happened. Okay.
Right.
I feel better now. But like, I want people to hear that. Like,
yes.
That's what's available to us now. Now, I'm not saying there aren't problems, and I'm happy to hear them, but okay, I'll shut up. But dude, it drives me crazy. That's a big deal.
It is a big deal. And it's a big deal that either isn't recognized because we have decision makers so far removed from our community that are trying to micromanage our community, or they're taking their priority of what's important and imposing it on what the community has decided is important. And I think that gets dangerous,
I agree.
right? Like legitimately it gets dangerous. And we'll see, right? Because again, the institution survives appreciating the boundaries and the structure of where we're at. But elections have consequences. Mm-hmm. State elections have consequences. We all know and are living through the national consequence of national elections. But hopefully it inspires people to vote and get more engaged. And litigants who are told for whatever reason, I'm sorry, but I can't get you a hearing on this issue for 3 months. I know the Texas Rules of Civil Procedure say that I could file a motion and get a hearing in 3 days, but for whatever reason, A, B, or C, your issue, your controversy doesn't get presented for 3 months, despite what it says in the Texas Rules of Civil Procedure, right? Like, I hope people hear that and recognize that maybe they need to be exercising their votes differently, not just in local elections, but our state elections, right? And who knows, maybe the people who are running for the Texas Supreme Court feel the same way, and the The decisions in November of 26 are going to keep things as they are. But what we are working with now is the Texas Supreme Court, who has proposed rule changes that, while it quote unquote permits exchanges of benches, the central docketing space, what happens in Atascosa, what happens in some of our smaller counties where judges are switching benches, it requires ultimate responsibility. I think those are the words, ultimate responsibility for every decision that is made in that case to go back to the shoulders of the originating court. So as cases come in our civil district court cases, as I understand it, right, our cases are assigned on rotation, right? First case is assigned to the 37th, then the 45th, then the 57th, and so on. Yeah. And then it starts anew, right? Case number 15 goes back to the 37th, right. and it keeps going that way. So what the Supreme Court is proposing is that ultimate responsibility is tied to the court that randomly got assigned that case. It's going to take some work to figure out how we maintain the presiding court system and also honor and respect and follow the rules from the Texas Supreme Court if that proposed rule becomes the final rule, which I think is up for vote or for ratification or whatever their terminology is, right. In May. No, I'm sorry, in March. And then the expectation is that the rules will be fully implemented 4 months later in July. I think that's the proposal that came out last year. So with that in mind, our colleagues, our bench, our 14 courts, we've been meeting and trying to figure out, okay, what does it mean? What do we need clarification on? Logistically, what does that look like with our current system? This ultimate responsibility, could it mean that cases that are, one attorney or the other has the opportunity to petition the originating court for a review? So then we start getting into this space where, maybe it's a final, maybe it's going to be reviewed, maybe we're treating district courts like associate judges and having de novo review with the originating court. I mean, I don't know.
Right.
I don't know what it's going to look like, but I do know that the majority of the civil district courts in Bexar County, recognizing that what's important to our community is access to justice. And we're going to do our best to preserve that.
Do you think the rule, and again, the answer is probably I don't know, but as the rules proposed, does that leave room for maybe a final hearings have to be in front of that judge, but everything else, motions to compel, sub-counsel, everything else can be through a presiding, or is that just it's up in the air?
I mean, I don't know. Yeah, it's up in the air. Yeah. It's up in the air because what works best with our presiding court is that no particular case is restricted by the schedule of an individual person.
Yep.
Right? Court is open. We'll navigate it, we'll push it, we'll document it, we'll render according to the law, right? But court is open. What that looks like when we start pulling things away and having this like hybrid situation, which we already do with our motions for summary judgment.
But that's recent. That's like a month or two, right?
Right. I think we did it 2 months ago. That was one because the legislation, actual statutes have dictated timelines on when those motions get resolved, excuse me. And it was easier to manage individual dockets, kind of just getting a report. Here are the motions for summary judgment filed in the 45th. Okay, let's time them out.
Yeah. That you're also in an awkward situation, and this isn't to talk good, bad, negative any colleagues, but 2 of the 14 judges as of March 1st have said we're just opting out of presiding. If I understand what the report says, and so now there's even more confusion because we have 2 courts that, because when you were practicing, we e-file it. We don't know what court we're filing in. I guess if I called the clerk, I could cherry pick. I guess if I called them, like, wait till you do it, that's probably against like a million ethics. But I mean, I guess if I want to do that, don't do that. So, we don't know. So I have a 1 in 14 chance of getting whomever. And if it's one of those 2 of our colleagues who I love and adore, I have no issues with them personally at all. Now maybe we have 12 judges doing one thing and 2 doing another. It's tough, but y'all are in a bad position in my mind. I, I know in Houston, and I don't remember which county is this, but they do have non-centralized dockets, individual dockets, but their dockets are smaller. Like the caseload percent, like how many cases you have to have are smaller, one, and each family district court has an associate judge. So now you've got 2 people handling a smaller caseload. So I mean, my snarky response to people is like, if that's what you want, maybe that's ideal, then add 4 more benches and add 14 more associate judges, then fine. You know,
And don't forget the coordinators who are supposed to be running these
correct.
reports.
Yeah, you're right. So now we need 14 more positions. So what are we adding? 28, whatever jobs. I'm adding 35 more jobs. And I don't know that we have that anybody has the stomach to put up that kind of money to do it that way. And maybe that if that's the right answer, great. But then put up for that in my mind. But until we do, it's hard for me to be like, we have access to the court, pure and simple. And I mean, I don't mean to just mimic what you say, but it's going to be hard to practice. I mean, it's going to change how it is, and I think but the brunt of it, as you keep saying, is the people who need the court the most. You know, you'll adjust, I'll adjust, but the people who need to get a temporary restraining order, the people who need to get a protective order heard, and even smaller things like motion to compel discovery. Now the case is 6 months longer. Okay, I'm done.
Well, and our community will adjust too, right?
Fair.
Like
Okay.
and I don't and I appreciate and respect that my colleagues who are looking to do an individual docket and who have made the request and the request has been granted by our local administrative judge, right? I appreciate that they're also doing their very best and prioritizing, right?
Right.
How they're interpreting the rules from the Supreme Court and how they are going to apply their particular interpretation to their responsibilities. And I think that's a good opportunity for us to have this conversation, right? Like
Yeah.
following the law, we need to remind each other that it's subject to the interpretation of the decision maker. And I respect their authority to work on
Sure.
their interpretations just as much as they respect my prerogative and authority to work on my interpretations along with the other 11 colleagues that are working towards preserving and establishing a presiding court system that serves and maintains what we prioritize, access to justice, and follows and complies with what our Texas Supreme Court has required of us.
Again, none of my comments were intended as negative towards them. Generally, it's just I can't imagine what the confusion is and frustration in y'all's circle is as the Supreme Court's, I'm going to say micromanaging. You've been very careful and kind with your words, but micromanaging, proposing legislation or proposing rule changes, implementing rule changes, and now they're trying to follow the rules the way they think is best and appropriate. You are, and it's a mess that maybe didn't need to happen, and that's where it originated. So again, that's not disparaging those two. They think they're just as frustrated as everybody else. Trying
I
to
agree.
do its best.
And I do wonder, like, what this looks like when the Supreme Court wants to micromanage the court that takes 3 months to hear a writ of attachment.
Mm-hmm.
What are we going to do about the jurisdictions for resource or capacity or prerogative do not give you a hearing in 3 days?
Mm-hmm.
Where's that micromanagement coming in? And what is that going to look like when they juxtapose what's required to micromanage a central docket? And that, I think, is going to be the test of the propriety of what's happening.
And I know in Comal, your colleagues that you don't get to work with as much because you don't get to practice in some of these counties. They're doing their DWAPs a little different, a little quicker, and they've been having to put with the new rules on like family cases have to be heard in a year or 6 months for like what, and they're having to put DCOs on every case and add things. So they're already feeling that pressure in different style dockets and individual dockets. That's fine here in Bear when you have the presiding system that you can create an administrative remedy, right? Like you could just have a clerk watch and say they're all DWAP'd and it's up to the attorneys to show up and then you can do it. you did an individual docket. Now you've got a judge having to do DWOPs every month. It's a lot, and I can't imagine that was understood or anticipated by our decision makers up in the Supreme Court. It's hard to believe it was. Whether I agree with it politically or not, they're too intelligent to have looked at that fully and then come to this conclusion, is what I would say. Like, you know what I mean? Like, yeah.
Well, and part of it is, what is your basis of experience to inform that intelligence, right? And so if you've never practiced in trial court, or if you've never handled a family case, then perhaps your experience needs to be augmented so your intelligence and experience can match.
Yeah, right? Yeah. Any other comments you want on the presiding? Are you good there?
I think and I hope that no matter which docket our litigants and our attorneys are operating under, the confidence in the institution is still there, right? You've got really hardworking people interpreting the law the best they can and in good faith fulfilling their obligations. And I think if we maintain that perspective and recognize collective prerogative and individual prerogative of our decision makers, it's going to work. It's got to work.
Yeah.
And our criminal state district courts, they've got individual dockets. They've been running those individual dockets. The county has funded the resources necessary for those individual dockets to run. I think our county administrators, our county executives, right, our commissioners and our county judge even need to refocus and prioritize their responsibility to the judiciary, right? And for too long, at least since I've been on the bench, there's been this expectation that we can shortchange the civil district courts because of A, B, and C. And I think some of that comes from not respecting the decision makers that are there. I think some of that comes from professionally, we've probably made it easier for them to not fund our needs. And I think that needs to stop.
I would agree. If it's okay, I'm going to switch gears.
Sure.
You have referenced, and again, I want you to be comfortable and talk about what you do or want to talk about, but you referenced appellate litigation in your court, 22 to 25. If I understand, you're referencing appeals from the Department of Family Protective Services out of your court. And if it's okay to mention, it led to a reprimand you had publicly. I have no interest in sensationalizing that kind of thing. It just doesn't tweak me at all. But I am interested because a big portion of that was basically department litigation in your court, back and forth a lot. So I guess my first question is, I don't think you've worked for DFPS, but you've been, and we talked about an advocate in the court for parents. You're an advocate to a degree for children. I know you're an advocate for the law in your bench, but for children, best interest of the children, what is DFPS's role in your mind, and then your relationship to them as a judge? Because I know when I read the reprimand, but I also read some of the cases behind, there's this notion that they're executive and almost not subject to your jurisdiction, which was interesting to me, because you're availing yourself of a court to take away kids, to do conservatorship. It sounds like what I do every day, but somehow it's different when you're doing it. So I want to give you the floor. And I don't want to say to defend yourself, because I don't know that maybe you have anything to defend, but I want that discussion open because it got pretty nasty in the news. So.
It did, and thank you. And so I'm not going to defend myself. It necessarily. I take this opportunity as like one of education and conversation. I did accept the public reprimand from the State Commission on Judicial Conduct in May of this year, and it was something that I was not even aware of until December of 25. And so I bring that up. I think it was December, but late 25. And I bring that up because 24?
Last year was 25.
Last
month was 25.
Oh, I'm sorry, 24.
I was just
yes.
making sure. I was making
yes.
sure. Okay.
No, thank you, because now I'm like in 26. I still think we're in 25.
Fair. Okay, sorry.
So in 24, December
Yeah.
of 24. And I bring the time frame up though because one of the complaining letter writers, and I say plural.
Yes.
At the time the initial complaint was made, was a sitting justice on the Fourth Court.
Oh wow.
And still was writing as though she were an objective arbitrator of decisions, and I think that was problematic. But nevertheless, I responded to what I needed to respond to. I followed the rules, and the State Commission on Judicial Conduct had the prerogative to make their offer, and it is what it is, right?
Yeah.
It is what it is. But
I have our history. Like I'm not. That's not it. This isn't me coming into judge. And again,
oh no,
it's but yours is more interesting to me. And the reason is like I earned what I got. I'll just say that I had drug problems in the past, and it is what it is. I'm not ashamed of it. Happy to talk. I've talked about it at length, and happy to talk more. But yours, a lot of it. Some of them were colleagues of ours. I don't want to talk about, but a lot of it rested on. Well, it's just I'm friends with everybody there. You know what I mean? And I'm not here to like. I don't want to pick sides or whatever. It's happened. But for me, it's there were a considerable amount of appeals. I think 14, if I remember right, back and forth, or mandamus decisions from the Fourth Court. But I'm curious, like, what was the tension there? Because like you're one of the smarter individuals I've met, you know, and you obviously are passionate about what you do. Where's the tension in your mind if there is a common thread that was going back and forth between what you were ordering for the department and what the Fourth Court saying no to, and it was going back and forth, which is to me it seemed the major basis of the commission, I guess, I'm going to say alleging, and that you're not respecting the Fourth Court, like, which I don't think is what you're trying to do. But where is the tension for you? Like, what's the thread there, and where's the disagreement you have? I guess if that's the right way to ask the question.
it is, and it's multifaceted, right? So we'll start with what the law is, right? The law, the statutory framework that's been set up by the legislature for termination cases in our foster system, if you will, is court central.
Yeah.
Right? So as you had mentioned before, the department comes to the court and essentially asks for termination, for that termination decision, and asks for an appointment of a sole managing conservatorship or conservator over that child or children, the subject of that case.
Which is the same appointment a parent is asking for when we're going. Sorry, but I just want to be clear. Yeah.
Right.
Yeah,
No,
they're
no,
asking
no.
to be parents, pseudo-parents for the kids.
Right, and that's the thing. There is no separate statutory scheme for the parameters of a conservatorship appointment. If it's the department, or if it's a parent, or if it's a non-parent conservator, like it is what it is as far as the roles, duties, and obligations when you're asking for that conservatorship appointment. And so when the state of Texas comes to the trial court and says, you know, here's the affidavit, here are the concerns, here's the risk, here's what the evidence is going to fall into categories, whatever it is now, 1 through 24 of a basis for termination. And because we're asking to terminate this child's biological parents or court-appointed conservators, we are also asking for you, court, to appoint us as the conservator of that child or children at issue. And with that appointment comes the oversight. And that's very clear. Like
Yes.
the statute has said periodically, even post-termination, until that child is adopted and there is another parent or conservator appointed for that child, the state of Texas is being overseen by the judiciary, which is where their rights were granted from in the first place. And in all things, with all children, the Texas legislature has required our trial courts to act in the best interest of our children. That is, if you will, the golden rule. That is the standard. Above everything else, you are to, trial court, act in the child's best interest. And you are, trial court, to oversee the department in their obligations to the child, right? Because you appointed them.
Yes.
And that makes sense. Like the statutory scheme and the separation of powers, it's all laid out in the statute in the family code. So, as I understand the case law's evolution from the Fourth Court, and I'm happy that no other appellate court in the state of Texas has done to our foster children what the Fourth Court did to them from 2022 to 2024. The Fourth Court had accepted the department's briefing that somehow, some way, when they are the permanent managing conservator of a foster child, the trial court's authority starts getting whittled away. They've adopted this separation of powers that somehow the trial court cannot order the department to meet the children's needs because the department stems from, and their case law went back and forth, somehow stems back to the executive, and they were saying it stemmed back to the legislature, and it just became this mess of precedent that was hard to navigate, right? And so I'm appreciating that they're the superior court, that they're the appellate court, and I'm trying to apply their evolution and interpretation of the statutes along with the actual statute, right? Like we've got the black and white.
Yes, it's there. Yeah.
Along with these children who were the subject of these appeals were high needs children.
Yeah.
There were children who had not been educated for over 5 years while in the state's care. There are children who didn't have licensed placement. There were children who were being sex trafficked. There were children who had surgeries and weren't taken to physical therapy. There were children who weren't going to school. I mean, we had, and probably still have, foster children who are quote unquote aging out at 18 who haven't sat in a classroom and passed a grade since they were 11 or 9.
So they might as well walk to Haven for Hope. I mean, where are they going to go, right? I mean,
well, and you know what's so saddening on some of these cases? That's exactly what the state's plan was. And some of these caseworkers and some of the supervisors and the management that we had were so callous and disregarding that they would have these conversations about, okay, well, at 12:01 on your 18th birthday, we'll just drop you off at Haven for Hope. Like, what were we doing and allowing collectively, not just as the judiciary, but as our community? What we had allowed to happen to our foster children was appalling. But the tension is having the trial court see this, hear this, get the evidence, make orders that were in the best interest of the children as the legislature required them to do, and then folks in Austin appreciating that they were also navigating as defendants in federal litigation, that our state of Texas has a lawsuit that it's defending because our CPS system is so unmanaged. Yeah. And so they're defending against that federal lawsuit and trying to make sure perhaps that they make an example of a trial court judge that's trying too hard.
I want to break it down again, because we're in this world. I think we're communicating. We know each other, and we know this. We've done these cases before. If you had two parents of a high needs child, and you appointed parent, make it easy, the mom. Imagine I'm not trying to be insensitive to anybody, but a nonverbal 16-year-old autistic child with a physical disability, and dad was just for some reason unavailable to do that. You would make orders. They have to go to physical therapy. He has to go to speech therapy, or he has to be fed. I mean, he has to meet the schedule. No one would blink an eye. No one would blink an eye. And we do it every day. I ask for these things from you and your 13 other colleagues every day when I go to court. We need, sometimes it's generic go ahead, please. Well,
and prior to 2022, June of 2022, when these cases started coming down from the Fourth Court at the time, nobody would have blinked an eye for the department being ordered to do exactly what they were supposed to do as the managing conservator of that child.
Yeah.
Nobody. But this case law evolution that happened from 2022 to 2024, it's just horrific.
Well, do you feel like were you sterner or more aggressive in your mind, that like you were taking it a step further? Were you in any way trying to make an example, like this is not okay?
So that's an interesting question.
Because degree matters too, right? Like, like how we do it, the degree to which we're doing that.
And I think that has probably been part of my evolution as a judge, just generally.
Mm-hmm.
Again, when we talked earlier, I think I have a greater appreciation of how I'm being received and making sure that my expectation and my intention are more in line with how I'm being received. I don't, but let me say this clearly. I've never intended to make an example of CPS or the Department of Family and Protective Services. Mm-hmm. They are an agency that is, when operating as it should, is truly doing God's work.
Yes,
they
absolutely.
are responsible for protecting our children out in the field, not in the courtroom,
Mm-hmm.
not in the schools, not in the doctor's office, but literally out in the field, going into people's homes, trying to make sure that our children collectively, our children, are safe and free from abuse. That is the gold standard. And I appreciate their work and I rely on their work.
Absolutely.
So I was never intending to make them an example. What I was doing always, and what I will always be doing, is making sure that decisions are made for the best interests of the children, because that's the law. And so if I'm hearing evidence that a child has had an operation and that doctor has ordered prescriptively physical therapy, and then I hear evidence that physical therapy appointments are missed, physical appointment therapy appointments are not even made, that the child's physical injury has been harmed because they haven't gone to physical therapy that was prescribed by the judge, right? When I'm hearing all of that evidence, my order is going to be take them to physical therapy now, take them on this day, take them on this time, take them, doing whatever I can to make sure that the best interests of the children are met.
And again, you can clam me up if you want. There's an arrogance I get from the department in general. Now, look, not every worker, not every of my colleagues. Honestly, the DAs I deal with today have been nothing but lovely in some of the cases I've had, and I'm not. But there's such a presumption from them that their recommendations, even the DAs in the courtrooms, are just, this is what we do, Judge. I tell everybody, if I took a family case with the exact same facts between a mom and a dad, the possession schedule in that case would be like, all right, one supervised visit with the amicus, if everything's okay, days only for this time, and then we go there. The exact same facts you put in CPS, twice 2 hours a month in Guardian House, and we're never going to deviate. And I'm throwing things at the wall, like when I turn the camera off on the Zoom hearing, you're just like, Judge, I don't care if that's how you do it. That's not what's in the best interest of the child. It's not even the law. It's not even what frequent continuing contact with the parent, attempts to reunite the parents. I mean, you know this better than me. The 60-day hearing, it says in all the permanency conferences, what does it say? If they can't show a continuing threat and best efforts, it's a shall return the children, not maybe. And I get laughed out of the courtroom. So there is this presumption, and I will, with all my love and deference to you and respect, I have felt like there's some rubber stamping the department gets sometimes, like they just kind of get what they want, and I throw my hands up some. I don't think it's malicious, but they've been enabled. I'll say that is what it feels like to me. And so when they meet someone who's like, no, we're not doing that, I do think it was I'm sorry, what? Like who's telling me what to do? If that's too far, I'm sorry, but I've run into problems because I feel like, I'm not going to say anything, but I had a case where the department simply, their investigation for some reason didn't yield what my private investigator found and was admitted in the stand, but the possession schedule didn't change. And the colleague, the person on the bench was like, you're lucky DPS didn't do it. Like, Judge, you can. It's like crazy to me. It's like almost like the department's allowed to do things like, no, the judges make the decisions here. That's like, I read the code the same way you do. Like, that's what we do. They can't remove a child. I know there's an exigent statute. They can do it, but they still got to go back to you within 24, 48 hours
prove it up.
and prove it up. But 90% plus of the cases are they go to you first to even remove the child before they can start the petition to terminate rights. And again, if you can tell a parent what to do, why can't you tell this? It feels like it'd be more paramount for you to tell a non-parent agency to make sure the kid's needs are being met, because bureaucracy can miss things all the time. Why wouldn't you want another set of eyes on the kid to make sure? So I don't know.
Well, and again, I'll say this. Our foster children in the 32 counties under the fourth court are in a different position than our foster children in the rest of the state. And I mean, thankfully the foster children in the rest of the state aren't in the same situation. But I do think we need to appreciate that our children in Bexar County and the 31 counties, other counties that are under the fourth court of appeals, they're not as protected, and the trial courts do not have the ability to follow the law in the same way as, for example, a trial court in Travis County or a trial court in El Paso County. But, things come up, controversies come up, and it's every opportunity for a new set of decision makers to evaluate the law and interpret the law and apply them to the facts. But I will say, I am not the court that rubber stamps much of anything.
I don't mean you.
No. But I think that's the difference, right? I think that's probably more than anything why I was an easy opportunity to make an example of.
Yeah, and I say rubber stamping. That's an incorrect use, and it's out of frustration. There's a deference to the department, though, that almost sometimes feels like an insurmountable presumption for the lone advocate. Not that I'm some meager whatever, but it's like, the department says it carries weight, as it should. I mean, you just said it. You have to rely on them. They're on the front lines. I tell people, when people ask what I think about the department, I say, they're the best sledgehammer in the world because they can do one good thing well. They can remove kids from horrid situations and save their lives. You get to nuance, it's hard because it requires training, it requires money, it requires oversight, and requires thought. And that's just really hard to do well. And again, it's frustrating that it turned into, I don't want to use inappropriate language, but it's a pissing contest almost between our, judiciary and a executive, when what was lost is what you continue to say this whole podcast is the kids' well-being. Like you can get mad at who ordered what. At the end of the day, like, why aren't the kids going to physical therapy? Like, why? Like,
that's the question, right?
Yeah, right.
Why aren't our foster children getting educated?
Yeah.
Why aren't they getting the mental health services that they're entitled to? And that they need? Why aren't we providing housing? I mean, it was a tough period for me personally to appreciate that regardless of my efforts, regardless of what I tried, some of these children did not get their needs met by their managing conservator. The department was not some agency that I picked off of the street, right? Like exactly. I didn't go and say, hey, Snap, come over here. Let me order you around. It was a litigant in the trial court that was getting orders. That's typical in every controversy that comes before the court.
Yeah, genuinely, I love to be a person that says let's have solutions when we complain. I don't, but what I've said to people, and this I think this will ring, this will grade your ears when you first hear it. But have sincerity, like remove less kids if you don't have the capacity to take care of the ones you do. And then complain to your funders and legislatures if you can't. There's a point where it's like, if you can't take care of them, you need to be careful with the mission you have. And I'm not saying kids need to be left in bad situations, but how many cases have you had that come in front of you that it's like, there's a hairline fracture we can't explain from 3 years ago and we're removing. Again, maybe there's a horror there, but if they can't meet their need, they seem to be like, we'll remove as many kids as we want and we can't take care of them. Stop telling us how to do our jobs. It's like, I don't know what to tell you, man. Get more resources or remove less kids at some point. And maybe that's too far, but because basically they're saying you're powerless to do anything about holding us accountable. Well, you need to be held accountable, department, however you want to assign.
Well, and that's just in the fourth court.
Fair,
right?
I get it. Yeah,
Other courts of appeals, and thankfully our Texas Supreme Court, have not made those statements and have not developed the case law that has existed in our jurisdiction. But I will say, and this is a danger that probably our legislatures and lawyers and community members who are engaged need to keep an eye on. They are removing less children, and they are being selective, at least from what the data shows, on the children that they are helping. And so we see less and less teenagers who are coming into care, and I don't think that means that less and less teenagers are safe.
It doesn't, and that's why I said it would grade your ears. But it's there's not a good answer there, and so then the answer starts to go to our community, the legislature, to be like, we need more education, more funding, more resources, and more places to go. If that, I assume that if I were given the department in your cases, the one we're talking about, the most credibility possible, the best intentions, if I was giving them their best version, we don't have the resources to do what the judge is asking us. And so you're telling us how to manage our department. I think there was some version of that. And yours is like, not in a malicious way. I don't care. The kid's needs got to be met. You need to figure, you asked me for conservatorship, meet their needs. And if that's where the tension is, then, you kind of got to figure it out. If I was asking you for something from the court for my 4 kids, you'd tell me that. I mean,
well,
right?
And that's the thing.
Yeah.
I do think that, and I don't know if our community appreciates this, but for a long time, our CPS region didn't even have a director.
Wow.
Like Bexar County, as large as it is, we were without a director, a regional director. I want to say for 2 years, maybe 3 years. And a lot of that comes from the politics in Austin.
Yeah.
Right? And again, state elections have consequences.
Yeah.
Right? And if we have a Republican administration for the state that doesn't respect or recognize or want to assist communities that they deem to be not with us,
Yeah.
we're in a whole world of hurt. And I hope that's not the case, and I hope that corrects itself. But when we've got our national politics being what they are, and then our state politics being what they are, it's up to our community just to get out the vote and make sure that our decision makers are doing what's best for the entire state or the entire country. But I think part of that was at play as well.
Yeah. I do want to respect your time, so I'm going to shift here to let you get to some of your other obligations. She asked, what's one courtroom myth you'd like to bust? But in general, what are some things maybe you want people to know about judges, how you make decisions that maybe they don't understand or consider, having been there 8 years?
Oh, so much.
As much as you want, but I know you're ready. I'm going to let you get out of here.
Right. So one courtroom myth. I don't want people to come to court thinking that the decision is already made. Okay. That doesn't happen. And I'm sorry that it feels like that happens. And again, part of that has been my own growth as a judge to kind of take a little bit more time, ask a little less questions, say a little less, right? So people don't think that what the decision ultimately was what it was going to be 5 minutes in.
Fair.
And so that is a courtroom myth that I think needs to be busted. The decision isn't on the wall. It gets developed with the evidence.
Okay. What advice would you give young lawyers that want to be a judge, or any colleague of yours that wants to go into the judiciary?
Get to court as quickly and as much as you can.
Okay.
I think I learned tremendously from my clerkship with Judge Clark at the beginning of my career. And so if there's anybody who's in law school who's already got an eye on, I think I want to be a judge in 15, 20, 25 years, then do the work and apply for the federal clerkship so you can learn from the decision makers here, present day decision makers. That being said, if you want to do something, I think you should get a mentor who's doing that already.
Agree.
And develop that relationship and get some insight that way.
As I understand the law, to be a district judge, you need to have 5 years of your law license and win your election. Did they change that recently?
I think they changed it maybe 2 legislative sessions ago, or maybe it was in 25. I don't remember if it was 23 or 25, but I believe it's 8 years now for the district court.
Knowing what you know now, 8 years in, what requirements would you have to? It's a big job. It's a lot to expect. I don't want it. What requirements would you put on, do you believe, or are you fine with 8 years in the election process, 8 years of experience in the election process?
I don't think, I mean, you could practice for 20 years and still receive cases and not know. So I appreciate what the legislature has said as the baseline. I think once you become a judge, I would like to see more education and more focus on the softer sciences of, again, the psychology of decision making, having an appreciation of the flaws of the litigants that are before us without being so judgmental. Isn't that funny? Because that's the job. Yeah, that's the job. But maybe some more training and some more education on how to motivate and be less rigid, and again with this eye towards how am I being received.
Okay. I want to close with the fun thing. I didn't know this. You wrote a book. So please tell me the origin, the inspiration, and your thought behind that, and I want to see that.
So this was, it was supposed to happen every year, and it hasn't. We still haven't gotten our second courthouse adventure book out. But this was to educate the public and especially educate the children about the courthouse. And the inspiration comes from different places. One is just in talking with community members during the campaign. People don't want to come to the courthouse, right? Like they don't appreciate that it's an institution that is open most to the community, because they associate the courthouse with incarceration or bad feelings or bad outcomes or negativity. Like there's just this aura of if you're at the courthouse, something bad is going to happen to you, right? And so I wanted to dispel that. And obviously the children are receiving what they have from their adults around them. So I think if we can educate the children to be more comfortable and more knowledgeable about the courthouse, then some of that negativity starts to dissipate. And the second space or inspiration for this is that our senators, our legislatures do things like this. Senator Menendez has a book that he gives to children.
Okay.
And I was like, if they're doing it at the State House, we can do it at the courthouse. And so Robert Vargas, a friend of mine, and obviously a political professional, we worked on this, and he's like, yeah, I can help you do that. And so that's what we got.
I love it.
And he's going to help me do the second one too, but it's just kind of keeps going off and on the to-do list.
I wanted to give you an opportunity to make your pitch for your third term, if you wanted to.
Yes.
But yeah. Please.
Yes. Well, you're a voter. I would love your vote. I think I'm doing a lot of good work. I think justice without exception is not just a campaign slogan or a motto. It is a sincere commitment and a purpose to our community. And so I'm looking for votes. I'm looking for support to make sure that I can continue to protect our children, defend our justice system because it needs defense, and make sure that each person that comes to the court has justice without exception. So hopefully I'm getting your votes.
Sincerely, thank you for coming on. I think it's, you've been in the press with some negativity, and I think it's very easy to, hide's the wrong word, but avoid a place open. We know each other somewhat well, But we haven't spent a lot of time outside the courtroom together. Maybe the halls at a couple campaign events. But you came on to a place you didn't know. We sent you something in advance, but I was clear it was an open conversation. So I don't think that's easy. And to anybody there, when people come on, I'm candid. Like, if you don't want to talk about it, we won't. There wasn't a topic you said you wouldn't touch. So, and I think I appreciate the candor and the respect to people who you serve and people you're asking for their vote to address things like a reprimand or things like a presiding system and places you disagree. I think it's very easy to be a politician and just, they have their deal. No, you were very candid about it, and I sincerely appreciate that, and let people make the decision for themselves. So thank you so much for that. I appreciate it.
Well, thank you. And it's respect for you, too. I appreciate you doing this and educating the public. Thank you.
Thank you. Well, as we wrap up today's episode, I do want to thank Judge Mary Lou Alvarez for taking the time to share her perspective and her service to our community. If you would like to find out more information about Judge Alvarez or take part in a re-election, the information will be in the description. So I'll have a link to the book, but a link to your campaign website. I don't know if you have several, but please give them to Ashley so she can have any links you want, donations or campaign events or anything like that. That's it for episode 11 of the Fiegel Files. Thanks for tuning in. Stay tuned because next week we're sitting down with Jay Dickens, a highly accomplished competitive strength athlete and owner of Relentless Strength and Promotions. Until then, hit subscribe. Don't miss an episode. If you need legal help, visit me at divorcelawyersa.com. Follow me on all social media platforms. Stay strong and go LSU Tigers.
There you go.
Thank you. Thank you so much.